Hey everyone, thanks for joining me on this very special and exclusive interview. I have a very, very special guest today, a person that I think will help the dental profession at large clear the air on some of the rumors and so on and so forth regarding the American with Disabilities Act, specifically Title III, regarding your practice's website. As you know, there's been a lot of buzz with what is compliant, what is not compliant, what do you have to do, and so on and so forth. And I brought a very special guest on. His name is Carl Kronenberger, and he is from an internet law firm who specializes in internet law specifically out of San Francisco. Very, very happy to have him. Carl, thanks for joining me. I appreciate it.
Well, thank you, Greg. I appreciate you inviting me to this interview.
Yeah, we're excited to talk to you today. Obviously, tell people a little bit about your firm and what you specialize in, and sort of, a little bit about where you come from, especially regarding specifically, internet law relating to the ADA.
Sure. Well, again, my name's Carl Kronenberger. My law firm is Kronenberger Rosenfeld, and we are a boutique firm located here in San Francisco. We focus just on internet technology and media law. We deal with a variety of types of statutes and regulations that companies that either do business on the web or have websites have to comply with. We also deal a good amount with government investigations, FTC, for example, and some DOJ investigations. We deal with the ADA from time to time as well. It's something that is becoming something that people are sort of forced to deal with, especially companies in specific professions, like, for example, dental professionals.
Right.
So if you want, I can give you some just a brief overview of what the ADA is. Is that fine, Greg?
Yeah, let's start there. Let's start with for people who maybe you're under a rock for the last few months and not understanding exactly why we're doing this, but let's talk about what the American with Disabilities Act Title III is and how it became about and how now it dovetails into sort of our modern technology, and sort of just surmise that for everyone so they understand why this is happening and just what everything is.
Be happy to. So the Americans with Disabilities Act is a federal statute passed in 1990, and it prohibits discrimination against people with disability or disabilities. There are a number of different sections of this statute, and Title III of this statute it prohibits discrimination against people with disabilities in places of public accommodations. So the question is, what are places of public accommodations? And there's this laundry list of 12 categories which are, by definition, public accommodations under the statute. And it's a variety of things. They're, hotels, motels, restaurants, convention centers, laundromats, parks, zoos, elementary schools. One category, specifically Category 6, deals with professional offices, professional healthcare providers, and other service establishments. So I think it's pretty clear that dental professionals, dental offices are going to be places of public accommodation under this category number 6. So that's going to prohibit dental professionals from discriminating against people with disabilities. Now, this law, it can be enforced by the Department of Justice, but it can also be enforced by private lawsuits by private plaintiffs. Now, when private plaintiffs sue, they can only get injunctive relief. In other words, they can only get an order for someone to do something, to sort of build a ramp or fix a website. They cannot get money damages. but what they can get is attorney's fees. So a lot of these
Okay.
suits that you see are driven by attorney's fees. So the question I think that you may have, Greg, is, okay, we have this statute, but how does it relate to websites?
Right.
So
And I think that's the million-dollar question, if you will, is how does that dovetail into websites?
yeah, so we'll go back to July 2010, where the Department of Justice put out this, it's called this Advanced Notice of Proposed Rulemaking, where they sort of put it out there for discussion, and they wanted people to comment on this idea that Title III of the ADA reaches websites. It reaches websites of entities that provide goods and services that are within those 12 categories that I talked to you about. And again, Category 6, that's going to include dental professionals.
Right.
So they asked for comments. And they also asked for comments about whether or not the Department of Justice should adopt certain standards, like these Web Content Accessibility Guideline 2.0 standards, which you see out there. We'll call them WCAG 2.0 for short.
Sure. Sure.
So they started to get comments. I think they initially got, over a course of 4 years, I think they got like 440 comments. And they decided it just wasn't enough. So they extended the time actually twice because they wanted more comments and they just weren't ready to make a decision. They've come out multiple times and to say that it's coming. Further advice is coming, but unfortunately it hasn't come yet. So we have this unfortunate situation where we don't have any clear guidelines. Now, there is one thing that happened recently. In January of this year, 2017, the U.S. Access Board. Now, this is an organization that sort of sets standards regarding disabilities and providing accommodations to people with disabilities for the federal government. They said that they were going to adopt WCAG 2.0 criteria, standards, and they wanted all businesses to comply with these standards within 12 months. That would be January 2018. Problem is, they don't enforce this statute. It's the Department of Justice that enforces the statute, and this is not really doesn't constitute the force of law, but they have adopted it. So what we have is this huge gray area where people
Right.
are struggling to figure out what the actual compliance guidelines are. But despite the fact that it's a gray area, here's the fact that is extremely frustrating to businesses in the U.S. People are getting sued. There
Right.
are a lot of private lawsuits out there, and Greg, I'm sure you've spoken to a lot of your customers who have gone through this, dental professionals.
Yeah, we have, and I think that's a good point. Is we sort of have this dynamic right now, like you said, where this is as clear as mud. But like you mentioned, the cold hard fact is that you can be sued for this. There are demand letter packets being sent to dentists pretty regularly, and sort of they're unfortunately low-hanging fruit with this.
Yeah. Let's talk about that concept, Greg, of low-hanging fruit.
Yeah.
Because I do believe that dental practices and medical practices are low-hanging fruit here, because people go into those offices. If you have a web-only business where you're not inviting the public in, there's actually some good arguments under case law in the U.S. that you're not a website is not a place of accommodation, because there's no sort of brick and mortar location where people are coming in for services. But dental offices and medical offices are places where people are coming in, and maybe it's a profession where people aren't paying as much attention to their websites as they would otherwise. So I do believe it's low-hanging fruit, and there are dental professionals who are getting sued. But let's talk about what happens when when a dental professional gets sued here. There are there are a good amount of suits being filed. We've done some analysis here at my firm on the suits. It's a majority of the cases are being filed by these professional plaintiffs, and actually three firms are filing most of these cases. And the settlements are going mostly to attorney's fees and costs. Now,
of course,
you do have the possibility that the Department of Justice will intervene, and that sort of brings it up to a different level here of concern. But even if the Department of Justice doesn't intervene, if when people are sued, they are almost always paying out settlement money, even if it's nuisance money where the claims are questionable. We've done an analysis about what people are paying, and I don't know how. We gather as much information as we possibly could, but companies are paying between $10,000 and $75,000, and sometimes significantly more. But there's a lot in that range. But so the point is that if you're so-called low-hanging fruit, there's a chance you're going to get sued, and if you are sued, it's pretty much an automatic expense, out-of-pocket expense to pay your counsel, because this doesn't count. This doesn't, figure in the money you have to pay to your attorney to defend
right.
you.
That's just what you're paying out.
That's right. So it can quickly turn into a six-figure situation. So that is,
and that's just legal fees. That doesn't include, that was one of the other things you mentioned, the DOJ intervening, which is always an unknown, but they could levy their first level of fine on top of that. Is that correct?
That's possible. I think let's look at all the potential costs here. We have money you have to pay to your own counsel. You have attorney's fees that you would pay to the counsel for the other side, but then you also have money paid to contractors where you've got to fix your website in very quick order without the luxury of being able to do it at the best cost and on your timetable.
Right.
The timetable is being dictated to you, so costs are generally going to be more in that situation. So the question is, how do we avoid this private litigation? As I mentioned, the DOJ does intervene from time to time, and we've got a handful of these interventions over the last 5-7 years. I think the big takeaway with the interventions is that the Department of Justice is adopting these WCAG 2.0 guidelines, or at least in the settlements, they're forcing these defendants in this settlement to conform to WCAG guidelines. It seems like virtually every one of these settlements where the DOJ is involved, that is the guideline, the WCAG guideline.
That's what I've identified as well, and I think that's where right now with the rumor mill swirling around the industry right now in dentistry is a lot of people think they don't have to comply until 2018. And that's really not necessarily true, because based on what you've told me on this interview is that really they're just thinking about making guidelines in 2018, but they've intervened in the past and sort of have favored in writing in these settlements the WCAG guidelines. So there's a chance you may not get clarification even in 2018. We're just sort of presuming we are. But the enforcements, both on the plaintiff side and on the DOJ side, seem to have been happening for a while. Could you comment a little bit on why you would recommend, and I'm not trying to put words in your mouth here, but why you would potentially recommend a dental practice become WCAG compliant now versus waiting until 2018?
Well, it's pretty clear that the WCAG guidelines, or something very similar to them, is going to become the standard, and for the purpose of intervention, it is the standard. That's what the DOJ is requiring defendants to comply with when they settle. I think the thing that is frustrating for businesses is that there's a gray area here, and the fact that it's gray hurts businesses because it allows plaintiffs' attorneys to file and take advantage of this gray area because it's usually cheaper to pay a settlement than to litigate a case for a year and a half. So,
right.
So because of this gray area, and because we know DOJ is using WCAG guidelines, if you're interested in risk minimization and limiting the possibility that you're paying out money to litigate or settle these cases in the future, the best thing to do is to get compliant now.
Yeah. Yeah, and that's what we've been recommending, obviously, in conjunction with sort of what's been happening. And I think, one of the things is that I think it caught a lot of people by surprise, especially in the dental industry, because you really kind of were just plugging along, and then all of a sudden, this compliance issue comes out of nowhere, and you call your website company and they really don't know how to advise you on what to do, because it did kind of pop up. And that's why we're doing this interview, is we really want to make sure everybody has the help that they need and the answers to the questions that they have. And that's sort of one of the things we've noticed is a lot of web firms are sort of saying to their customers, we don't have to make your site really accessible until next year. And I think that's sort of a thing where, as a business owner, you have to sit back and, like you said, minimize your risk, because unfortunately, God forbid something happens where you get an attorney demand letter packet, or you do get someone who files on you just out of the blue. You've really already lost at that point, and your web firm isn't going to necessarily go to bat for you because they can't, right? And I think that's where you want to, like you said, you want to make your site accessible, just at a minimum to minimize your risk, right? Just like any other business decision you might make. So, and I think you would probably agree with that. No matter how you go about making that decision, is just to. I think doing nothing is almost too vulnerable, because we do know this is going on, and it isn't something that you necessarily can delay. So tell me a little bit about when you're a dental practice. We talked a little bit about low-hanging fruit. Let's revisit that a little bit. And what do you think, we've identified firms that do this, and I think the first quarter, I think ADA Title III suits are up almost 17%. From what I read from another firm that does a similar thing to what you do with surveying, is I feel like this website situation is just going to intensify over the next 10 to 12 months, because you said it's this gray area where plaintiffs' attorneys can really sort of pick and choose who they want to go after and who's just going to settle the quickest.
That's right. It's, at a certain point, it becomes less of a legal issue and more of a business issue, because on the legal side, you have this gray area, you have this environment where it's fairly easy for plaintiffs' counsel to sue and get nuisance settlements, which can be fairly significant, $20,000, $30,000, $50,000. So it's because you have that sort of reality, then it becomes a business issue, and that is, how do you reduce your risk of paying this money? And you do this cost-benefit analysis about, how much you may spend in litigation expenses and settlements versus how much you would spend on getting compliant.
Right. And I would tell you, just being an internet web firm, that when it comes to adhering to the WCAG, guidelines, it's not it certainly pales in comparison, expense-wise, to defending yourself by thousands of dollars. And I think it's not that hard to get to that point and where you can actually be accessible. And it certainly isn't a huge expense. And I think, like you said, it becomes a cost-benefit analysis. Are you willing to roll the dice? And we've had conversations with dentists who here in Austin even, where this has been sort of a hotbed because Texas has been a target for some of these things, who just say, I'm just going to roll the dice. And that's a business decision, right? I'm not recommending that because I feel like cost-wise it's easier just to get your site accessible and sort of move on. Because I think part of it too is, and I think, you and I have discussed this, it has to pass the sniff test, right? If your site passes accessibility standards according to WCAG, they really don't want to mess with that as much. You're not 100% covered ever, but the reality is they'd rather go and try to go after someone whose site, might be a few years old and it just has no accessibility whatsoever. Sort of making sure that your site is coded that way in particular is important. So for everyone out there, from your standpoint, we know there's been some cases where this has been vetted out. And I want you to speak on this, but there have been some instances where the courts have ruled that your site is part of Title III. There's been some others where it hasn't. So talk a little bit about what the case history there is and almost why that makes it worse. Because it muddies it up even more, I'm sure.
Sure. I think that the main argument is going to be this insufficient nexus argument, and there is a circuit split on this. The problem is this argument, this defense, doesn't apply to businesses that have a brick-and-mortar location where they invite customers in. So the best defense out there is really by companies like Netflix and other companies that are web only, because because then there's this argument that there's not a good connection between the services here in any physical place, because there isn't a physical place. So it's not going to be covered. The website's not going to be covered under Title III, but that just isn't available to medical and dental professionals, that defense. There are other defenses, but I think at this point I guess it's sort of hit and miss, and they're somewhat theoretical. So I think to present one of these defenses, you have to make the decision: do I want to fight like hell and pay my counsel a bunch of money to make these arguments and perhaps prevail in the end, or do I pay less money and settle? So often people don't even take this step of making these unique arguments, that maybe there's a due process issue, or maybe the attorneys didn't give any pre-suit notice. There's an argument there that the plaintiffs can't get attorney's fees, but in that situation, and then there's also standing issues. There's an argument that with these website cases that the plaintiffs haven't suffered injury, in fact. But the problem is you do not have consistent rulings throughout the country on these defenses. And I think some of them make sense to me, especially the due process argument. People feel that they're deprived of due process of law because they're being held to a standard which nobody understands. Nobody because it's too gray. It's too vague. and that vagueness creates this argument that they're being deprived of their property without due process of law. However, often it's cheaper just to settle, unfortunately. And
I think part of that too is we have to understand, in this side of things, our audience here, which is most of the folks that follow us and listen to our content and so on, are a small to medium-sized dental office who ranges from everything from just the one-person practice to, you might have a multi-group practice, but when you do that cost-benefit analysis, you're looking at cash outlay, right, that you're not going to recover potentially, or at least it's going to sit out there, which is never good, as opposed to, a large corporation like Netflix, who has piles of attorneys and piles of money to say, well, we're willing to dive in and fight this, and we don't really care about the money too much. We want to get to a resolution on this. We're not going to just pay you to make you go away. And I think that's where it comes down to, like we said before, is a business decision. And you put it perfectly. It's often less than fighting. And I think that's sort of kind of what we're surmising here, because it is such a gray area. And what's your opinion on, you are very familiar with how the government operates, and you've been doing this for such a long time. My thing of it is that, if the DOJ has said they're going to come out with more specific guidelines next year. My take on that is that that's like 50-50. It may happen, it may not happen. So, and especially under the Trump administration, will they regard that as a new regulation? And if that's the case, that causes its own problem. What's your opinion on whether or not that even happens?
That's a good point. With the change in administrations, there is a bit of a slowdown, and policies are getting looked at again and maybe questioned. And we have the backdrop here of DOJ actually intervening in cases. So we have we know there's a risk out there. We have a history even throughout the Obama administration of them dragging their feet because they were uncertain on how to give guidance, and now the guidance may even be delayed further because of a change in administration. So it's unfortunately concerning here for businesses, because it may be years more of dealing with this gray area where you've got the risk of private litigation and DOJ intervention without any clear guidelines. And in that, again, that gray area really only benefits the plaintiffs, because what often they're seeking is settlements which are less than what it would cost to fully litigate these cases.
And you've seen in the past too, is you may not get any clarification for years, even though they say it, because I think it wasn't in 2016 they mentioned that they were going to have clarifications, and then that got punted to 2018. So we sort of keep doing this every few years, and I feel like the longer that goes on, the trickier it becomes to navigate the landscape, because, and I think you have mentioned this in the past, that I've read it in some of your articles, where as long as it's as clear as mud, it remains sort of a dangerous environment, because almost anything can happen, and we're almost seeing it in real time. And you really have to look at it from, well, hopefully there is a day where we have some clarification, and I personally think there's going to come a day where, who knows when, having your site accessible will just be just as much of a standard as if you were to have a ramp or handicap accessible bathrooms, just because the way technology advances. I just see, I don't know if that's in 15 years or in 2, who knows, but I think that's where we're headed, quite frankly. So, I think we've covered quite a bit here, and I don't want to dive too deep into this and keep it sort of simple for everyone, because I think get some good takeaways from this and have some real clarification. I have one more question for you that I've sort of heard in the rumor mill as well, is I've seen people mention in the forums and on Facebook that if they have less than 15 employees, Title III doesn't apply to them. Could you weigh in on that a little bit?
Well, that standard is not a Title III standard. That's going to be the standard for discrimination in employment. But there is no minimum employee threshold for places of public accommodation. So it's really taking a standard from one part of the ADA, one title, and then applying to it another title. But that threshold, that exception, so to speak, only applies to the other titles of the ADA, for example, employment discrimination. You can't discriminate based on disability and employment, even if you have just one employee.
Right. So to surmise that, even if you on your own, a dentist in an operatory, by yourself, seeing patients in a brick and mortar situation, that doesn't exempt you, correct?
Correct. So the ADA Title III is going to apply to the dental practices, even if they have just one or two employees. I'm
just trying to address some of the rumors that float around. I see all sorts of stuff, and I just wanted to. That's why we're doing this, is to cut the fat a little and get to the nitty gritty here. And then one more question for you, and this is something that I've sort of read, and I don't have a lot of knowledge on it. Is you being in California, you have your own sort of version of the ADA law. And this is for anyone in California who's a practicing dentist. Is it the Unruh Act, I think it is called?
That's correct. And in these cases that are brought in California, they're often both ADA claims and Unruh Act claims based on the same misconduct. Are going to be statutory damages of like $4,000 per incident of noncompliance. So I think what that does, it sort of increases the negotiating leverage and the stakes a bit in California. Even though I think that it can be difficult in the end for them to win on those, still I think it does affect the negotiations and, as I said, the stakes.
Okay. And then we've also seen in a bulletin from the American Dental Association, one of their recommendations, and we've had this sort of come up before, is this concept of adding an accessibility link to your website, and then that will sort of keep you safe and warm. What is your opinion, or at least, idea of, not coding your site for WCAG, but then just putting a link up for accessibility that just says, hey, if you're having any issues, we're here for you. What's your thought on that?
Well, it's not going to get someone compliant. I can see why that organization suggested it, because there have been some settlements where, among other things, the DOJ has required the defendant to have an accessibility page and a link. However, DOJ also encouraged the defendant or required them to comply with WCAG standards. Mm-hmm. So I think it's great. I think that companies should do it, but I don't think it gets them compliant.
Yeah, I would agree. And I almost think that if you have just an accessibility link, and this is just human nature here in my mind, and you aren't accessible to the WCAG guidelines, I feel as if just an accessibility link, almost a plaintiff's attorney almost looks at that as they could argue you're aware of it, but you're not really adhering to it. It makes you almost put the bullseye on your back.
I see your argument there, where it could be viewed as someone doing something in bad faith, saying or implying that they're complying with the standard, but not, because having that page and saying you're compliant, but then not being compliant with the WCAG is perhaps a problem.
Right, right. And like I said, that comes back to cost benefit, sniff test, the whole thing. And that's just, some things with that. And, one of the things too is just while we're on this call, we'll be wrapping up now, is just to make sure everyone knows this is for informational purposes only. And Carl, I'm sure you have some opinion on that in terms of legal advice. I'm not an attorney. Carl obviously has not engaged with anyone listening to this, so you want to make sure everyone's aware, Carl,
that's right. I'm very happy to give you my comments, and I have in this interview, although I don't represent anybody listening to this, and so my comments aren't intended to be relied upon as legal advice by anyone. But hopefully my comments were just generally helpful to some people out there.
Oh, I'll be honest with you. You and I have talked about this topic in the past, and I've already learned more on this call. I do appreciate your time. This was really great. We really cut through a lot of the rumor mill that's out there and sort of painted a picture for folks where they can make a logical decision regarding their business now, right? You have options out there, right? You could do nothing, but you could also do something. But now you have information, and that's the most important part of running a business, is understanding, okay, where do I take this from here? And there are other firms, there are firms out there that will, including mine, that will, code you a site for the WCAG guidelines. And I think, that's where you start to weigh those options and cost benefit, and if you're going to do it, and so on and so forth. So, Carl, thank you so much for joining us today. I really enjoyed this. I learned a lot. I'm sure everyone listening learned a lot. So we'll include a link below this audio to Carl's firm if anyone has any further questions or would like to retain him for anything. He's a fantastic attorney, and so is his firm, well-versed in the areas of law, especially the internet landscape. So, Carl, thanks for joining me.
Thank you, Greg.
And